The Federal Court of Appeal will hear arguments today and tomorrow as the Toronto Police Association attempts to get the incarceration and parole files of 3 notorious killers released. The union wants the files of Paul Bernardo, Craig Monroe, and Clinton Gale released, as well as the audio recordings of their parole hearings. They say these records are key to protecting the public by keeping these men behind bars. The TPA initially tried to gain access to the records through an Access to Information Act request, but were denied based on the privacy rights of the offenders. Well, joining us now with more on this is criminal defense lawyer Joseph Newberger. Always great to chat with you, Joseph. Tell us a little bit more. Why would the Toronto Police and the families want to get a hold of these records? What would they say and what benefit would they get out of it?
So I think the TPA and the families would like access so they could review the institutional records, which is how a person is performing in the facility. But more importantly, take a look at the psychological, psychiatric records, the assessments, and then inform themselves as to submissions that they want to make at a parole hearing. We also have to remember at a parole hearing, the police associations and the victims' families have a very defined role. And it's not to expand to make submissions based upon risk assessment and other issues that would be derived from these records. So I agree with the initial decision, and I don't think the appeal itself will be successful, but I understand why they're bringing this application.
Well, I want to talk about the decision. The justice disagreed with the position and rejected it, and the alternate agreement that the public interest outweighed the purported privacy interest of the offenders. Talk a little bit about that aspect of this decision.
Yeah, so it's very important to remember that medical records, risk assessment records, psychiatric records, all those things are highly protected by privacy. And so when you have a select few of high-risk offenders and you want to try and carve out an exception for their records to be disclosed to police associations and generally to the public, that would then set a precedent for disclosing the records of other inmates or offenders that could go down the line of people who are far less of risk and may be in custody for a limited period of time. So it would rob these individuals of their privacy rights and would not have protection over very core, important information about themselves. And we have to remember that the parole hearings, they don't lose sight of the risk because the parole hearing is informed by the assessments that are done in the jail. And for example, Mr. Monroe's been in jail for some 42 years, and Mr. Gale's been in jail for some 27 years, appropriately. And again, given their risk profiles, they will remain in jail for a long period of time, if not the rest of their lives. So although the police may find this to be of importance and the families, overall, the parole board is very well informed from the jails and all the experts when a parole hearing happens.
Yeah, one of the things that they said, the TPA, was that these records are key to protecting the public by keeping these men behind bars. But, as you just mentioned, 2 of these 3, highly prolific killers, especially Paul Bernardo as well, probably a very unlikely chance that he will see the light of day and get out.
You hit it on the nose, so you're absolutely correct. All of these offenders are particularly notorious with high-risk profiles where none of them are likely to get a release. Certainly, Mr. Bernardo is not an individual who will ever be released from prison, and I suspect the other offenders as well will remain there for their natural lives. So it is not a safety risk. I think it's a precedent that should not be created because we still need to maintain these privacy interests.
And lastly, can the families and the TPA continue to appeal, or is this a done deal? What happens next?
After this appeal to the federal court, they can go one level higher and then possibly take it to the Supreme Court of Canada, because once you exhaust your appeal rights in the federal court, then the Supreme Court of Canada can hear the application or the appeal if they deem it appropriate. I think you'd need to seek leave for it. So this is but one part when you go to the Federal Court of Appeal, but this may end the argument given what the decision may be.
Criminal defense lawyer Joseph Newberger, always great to chat, and thank you for your perspective on this.
Pleasure. Take care.